country, lovely.
Why you nobbing?
Mate, the only reason we want to is we don't want to play the The reason I want to remain because Churchill had this fantastic idea, and I think you've come up with a better one. I just know I have to take a right.
No, who told you that? Your wife. Don't listen to everything she says.
I don't, that's why we get to where we need to go.
Ci vediamo. Ciao. What would be better, a general election or to keep the parliamentary seats right now? Because I'm not really sure which would be better for. What's your opinion about it?
Well, we don't want a general election, so I'm strong on
Good morning.
Jane.
Did you pay them? Yeah. Oh my goodness, you're amazing. Be careful with the rain though.
I know.
You want no lies. You know it.
Lies? You mean the sort of lies about?
He's a traitor, right? It's the flag of the Fourth Reich, dreamed up by Goebbels. Yes.
Oh yeah. We're going to be surprised.
Come on, you don't like I don't know because you know that gypsies are everywhere, but they have this I'm from my mother's part. My second friend is from
It's very
Do you know what
No, but I mean like that's terrific. Of course, so there's only I am. Reopening the parliament, but you just asking about so tell me why you are happy. Very quiet. Calm down. Yeah. Right. Yeah. Thank you.
We are concerned. Thank you. Morning. You'll talk to the grandchildren and recount the experience fondly.
Basically, so if we get a deal or it's a referendum, it's a yes.
You know more than I do.
I really had
I don't want you away from me if you want to stay.
But they didn't get the deal. I mean, people that we got a deal, and there are people who are on that deal.
You have many go in? No, the other thing is, I don't know how some of them look like. Suddenly appear that way. Some of the cameramen jumping. Actually, no, I don't. That's exactly the same. I noticed you seem to make
Nee, ist das einmal? Nein, das ist nicht. Nach rechts. Ja, das ist so. Also nach rechts. Like the last few weeks have been Been that poster around?
Funny how styling is gone.
I'm saying there is a hypothetical thing where something could happen. One goes up and all night. Good. Bombs go up and all night. All I'm saying is that there is something to every person. And if I I'm not using any of these. I'm saying that for every approach, there are very extreme people. And the guy who said, I don't care if I die from diabetes, I want to leave. There are some people on that. There are some people who are softly, do you agree? Who want to leave with a good deal and don't agree with no deal. Do you agree? A lot of people vote for me. The reason I'm here to support you people is I believe that there are at least 1.2 million leavers who, for them, their condition, like they do say it's very impossible to stop them leaving, trouble with the line, the economy goes down, people die of mental illness. For them, a no-deal Brexit is that condition where remaining is a better option than leaving. And therefore, I think that should be a second referendum. I know, but no deal might happen. A no deal might happen. Which would I do? 1.2 million leavers who think it would be better to remain than no deal. I'm talking about that. Yeah, but that's one's coming from the EU and coming from the EU. From the EU. So what you're saying is they'll be fine with medical price because they come from the UK. We get ours from the EU. That's the good. You've got to understand all the differences. British Medical Association, Royal Council of Emergency Medicine, Kidney Care UK, and Diabetes UK all signed a joint letter saying under the new ideas of no deal Brexit, there are severe concerns about the shortage of medicine. They all of them, well, you've got one Irish leader against 4 to 5.
Yeah, well, it's happened like here, bag, yeah.
Of course,
Never had
find someone who's kind of divide. Find somebody who's when the majority of people who work in the industry and the community say this is going to kill you, then I think you have to take note of that. That's not my concern. And if they want that,
Well, I come up here when I can. I've been for a while. Last thing I did was I got the orchestra together outside the last night at the Proms. Mr. Evans? So, yeah, everybody was so enjoyable.
my father checked the UK government, my father government website today. 3 of the medications that my father takes are on the no deal like panic list of drugs that might not be able to manage. I'm sorry, no deal is not worth people dying. There is literally no deal. So all the supplies of perishable medicines that come in with the supply chain, if we suddenly have no deal, they are legally not allowed to come in. So legally, they have decided that the rules of engagement that you're going to be trading with each other, they stop trading with you until you have a trade agreement. Basically, here's the stupid thing about no deal. There's a deal. You start renegotiating Parliament. Why are we here? A trade agreement. You don't need a single market to trade. You just go directly to no deal. We negotiated a trade deal with America. Once we still had other people coming in the EU, we are so dependent on the medicines and compromise and the trade and the immigration that we get from the European Union that to suddenly turn it off.
What's happened to online?
Step back and look and see that partially what would happen there's no
the Royal College of Emergency Medicine's job is to just emergency medicine to people and they told them
I have come here to demand my rights as expressed in the Magna Carta. The people are sovereign over parliaments.
Yeah, I spent 4 or 5 weeks staying around
What's the name of your Canadian broadcast?
Okay, thank you.
I've already been stabbed once. Why did you shoot me in the head?
Here's a gun.
Oh, yes.
This is ridiculous. You seriously think the UK government will stop importing drugs from abroad?
The EU will stop. Will delay them. The EU will delay them. It'll be delayed.
Be delayed.
Because we've got to have a trade agreement with them anymore.
You do not need a trade agreement.
So how would you get your medicine?
You would just import them as we do now.
Yeah, with tariffs and costs.
Yeah, with the standards.
With more cost than
paying a hell of a lot more money.
Would your British standards be the same as the EU?
But we control our standards.
Yeah,
We
okay.
control our standards.
Yeah, but would they be the same as the EU?
These MPs are showing nothing but contempt for the democratic vote of the British
The day
people,
after Brexit,
as voted in the referendum, as voted in the Conservative manifesto, as voted in the European elections. The polls show that people have had enough of this.
At this time, we were already out. 29th of March. Even Boris Johnson voted for that. Don't try to stick with that. Sorry, what? Why is not that? No deal was not an option when it was the
Why has it never had public support in the majority? Any poll.
Well, if you listen to Daniel Hania, he would say that you can be out, be seen in the supermarket. If you hear somebody else. Yeah, the amount of money was there. Unbelievable. And now saying that there was one day, 2016, about the no deal. Everybody was advocating for that, for an easy compromise, not to get to a great deal. Unbelievable. So that's
You're saying too hard, what we're doing. That's what you're the deal was rubbish. The deal was yes, you were compromised.
Because 70 million people wanted to leave.
But you compromise when both sides have something that they'll accept. The deal was not acceptable.
Well, the government doesn't accept it. When no
if something's hard, it's not worth doing. Just go back into your little shell. Where's your spark? If it's something's hard, it's not worth doing. Just go and try
I think she's on your side. Yeah.
That's all you're arguing with. It's too hard.
The argument is terrible. The argument is a sensible direction.
No. It's not cut your own feet off. You're not doing so the deal. You're saying you were
compromise the deal. Something around the deal.
to be honest. Absolutely, because if it's a great deal that come out,
I've just been accused of being arrogant and wanting to run
Are you saying that Turkey? Are you saying that Turkey
no, don't need any more.
One's too many.
But that's impossible. 100%.
Yeah, he does. But he does in real life as well.
I didn't understand it. It said vote to leave, vote to remain.
Yes.
Yes.
And you can also say Brexit is the problem. It's not remain, which is the problem. Remain in peace. So, well, now
Take the logic. They say, well, Brexit is a little bit thick. We didn't understand what they were voting for. What they should do, by that logic, disenfranchise and virtually the whole population. Because we all know the general election parties for issues that
no space, you're pushing it up, shoved in.
Go away.
we're getting paid for this, we're doing it behind this bar.
We're doing this because we believe in democracy. You're just looking to get them.
Is that a mercenary that said that? Oh, was that a mercenary that said that? No, I asked.
Can you go on the paper? You're gonna get pushed back. Couples won't like it, I tell you that much.
Traitors! Magna Carta! Magna Carta!
That was Ken Clark. The first car. I don't know the second car. You're so focused on the first car, you don't know who sneaks past. I'll be Boris in the boot. Yeah. I know he's not the bravest person. We should have all dressed up as judges with wigs. The whole crowd. Someone should be handing out comedy wigs.
Keep it moving.
That would be fun. Really? Give everyone a wig in this. I'm going mad. I think it's going mad.
Sorry for being in your way, sir. I'm now going to be asking a
Den gerade nicht schade.
guys. Guys,
This was a really good spot. Where are you? Why are we trying to get us in the minute? The only thing is that might be that I'm going to be in the lobby, but I think Sarah seems to be in there as well. It's the two of us. Yeah. Exactly. Well, I'll tell you the so it's just as good luck, cheers, mate.
What's going on?
Welcome back! Welcome back! Welcome back! Back to work! Get back to work!
Sorry? I think so.
Welcome back! Get back to work! Pay your salary! Welcome back! Thank you for coming back to work!
Yeah, if you want to cross.
Why is this thing like give me soon? Welcome to democracy. Good morning.
Welcome back!
you mind stepping over to the side?
How are you?
Go back to getting everyone back on the pavement. Just spread the word. Boris isn't coming here. He's got to stand. So just get everyone back. Push everyone back on the pavement.
Yeah, of course.
Traitors! Welcome back! Thank you!
Ladies and gents, if you start pushing that way, please need to open up. Ladies and gents, just keep moving yourselves back for me, please. Yeah.
The other 30 people you want to...
Yeah. Take that.
Wet. Folks, can you all move yourselves back for me, please, and give us some space for people to get past? People at the back, can you move yourselves back, please? Give us some space. And yourselves, just go back a little bit if you're going to stand here, that's fine. Just give some space for people to get past. Folks, that includes yourselves now. There's some space behind you. Could you move back, please? Keep going, folks. That's the spirit. Well done. Move yourselves back for us, please, folks.
So soon. He's late. He's missed the register. Press 11.
I can believe that. Why can't you believe Move yourselves back for us, please. Yeah, we're just trying to keep the path as clear as possible. Just move yourselves in as much as you can, yeah. Guys, what we're going to do is where the drop curve is, we're going to have a clear pathway so people can walk all the way through. So they're going to do it on that side if you guys want. Up to where? The barrier? As in, yeah, so just so we actually have a pathway. Wheelchairs that are having to go on the road. And about people, what about people here? They're right either side of where we're going to have a one needs to move. Thank you. Can we make this sterile, please? So people can use. You can go either side. Thank you. We start making a pathway, please.
Focus yourselves as well, even to the side there or to the side there. We're trying to keep this clear. So you're right in the way. Actually, you need to move yourself. Just wait. I appreciate it. You know what we've been asked to do. We need to simply people on this to get past. Excuse me, right? Yeah. So you can move yourselves that way or across into here. There's some space there.
Stretch. Keep it to move. So you're right in the middle of the pathway. Can you just move over a bit for me?
Just need to try and keep a clear path.
Central approach, showing it. But effectively, people are walking out here.
Yeah,
So effectively, it needs to be either a clear path there, and if you need to make a clear path, that's fine. If not, just push everyone back. Because the problem is, we're getting people with kids walking in the road. There's cars coming in and out this junction, so we just need a bit of clear area.
Everybody yourself, just looking under themselves, moving 1 and 7, probably about 4, I will be about 2, 1 and 0. Yes,
Why did it pass now? Thank you for your patience.
Keep coming, please, madam. Keep the pathway clear. Keep coming.
What's MG division?
He's not coming. If you're not heard, he's not coming. No, genuinely, he's not coming. This is what we've been told.
Yet again, we've heard outside of Westminster and inside of Westminster.
Boris is taking some photos. This one, just trying to keep
We are
this area
confident
clear,
that
so that people can get past and
hearing and seeing as the Prime Minister arrives here
you're looking to get past
to account after the Supreme Court made it
This is what we said over there. Might take out and leave that and leave.
Maybe it comes to the snowman at winter.
Yeah. That was a bit of you, Stretch.
See that coat?
That was a bit of you. Bowlers. I've just been kind of hard to do that. More than welcome to go. Thank you, no worries. Keep coming, keep coming.
Because the rain was then beginning to fall, and she's decided to put her trolley to keep herself dry.
I don't know, I wasn't looking.
Right, should we just keep this parked here, madam? Thank you.
Yeah. Keep coming. It's up there on the left hand side. Absolutely, please do.
But I run a bus. Joys, people. You value me, sorry. Keep coming. Yeah, keep coming. I know that's boring. That is all right.
You're already famous. What are you talking about? So why do you not want to be famous? Parliament started at 11:30.
I've been told I can keep my level 2. Not guaranteed that I'll be able to renew it every 12 months. Every 12 months. It'd be when I can fit in. So it's not a guarantee.
Be honest though, what are you going to need it for? Doing any... I do like to.
Just for the fitness and the fun.
I've come through, I'll clear the place.
Yes, cool. Thank you. Random mad first.
I think it could be the cleaner coming in, couldn't it?
I'll keep coming, or block, open up the pathway, you're blocking the pathway.
711 Alpha, go ahead, and then... You should wait. 711 Alpha, data 0711 Bravo, data. Go ahead. Stand by to 711 Charlie,
Thank you.
Stand by to 711 Bravo and 711 Charlie, units join 11 A Alpha, Coach Gate. That's the fire to the Bravo.
Was being mooted that Parliament might be prorogued from the beginning of September or even earlier until the 31st of October. I say straight away to my right honourable friend, if that had been the proposition, I could not have stayed in the Cabinet whilst it was done.
That's very different. Very different. Thank you very much, Speaker. Does the Attorney General believe that yesterday's judgment of the Supreme Court represented a constitutional coup? And if he does not share that view, explain to the House why he thinks that that is wrong.
General! I don't think it was a constitutional coup, and I know the right honourable lady, right honourable gentleman, right honourable gentleman. My honourable gentleman will know that I do, and I don't believe that anybody does. These things can be said in the heat, of rhetorical and poetical license. But this was a judgment of the Supreme Court of a kind which was clear and definitive. It often happens that governments lose cases. We didn't agree with it because, of course, we argued against it. But we accept the ruling of the Supreme Court, and we are proud that we have a country capable of giving independent judgments of this kind.
Bob Neal. Thank you, Mr. Speaker. Can I welcome the Attorney's very clear statement of the importance which he, and I'm sure the whole government, attaches to the impartiality and independence of the judiciary. That is most welcome. Can I also say to him that many lawyers might well have given exactly the same advice as he did on the weight of precedent. Does he accept, however, that it is most important that the convention, that the advice that the attorney gives to government is and is not disclosed should not be lightly set aside, but perhaps consider that it's rather regrettable that such an important matter, which warrants very careful and calm and considered language and discussion, should be used for the purpose of rather unworthy ad hominem attacks and a political knockabout when so much is at stake.
Yeah. Well, I'm grateful to my honourable and learned friend's question there. I do, of course, agree with him that their legal advice, and particularly the road attorney, is always difficult because one polices and intersects a very difficult line between giving advice of an impartial and politically impartial character and being a political minister. But I hope that I've endeavoured to, with all of the conscience and candour at my disposal, and when I say to the House, as I do today, we lost. We got it wrong on the judgment of the Supreme Court, but it was a respectable view on the law to take, and that view was taken by 4 out of the 7 judges who'd opined up to the point of the Supreme Court. The Supreme Court has made new law. Let's be absolutely clear. From now on, the prerogative power of Her Majesty advised by the Prime Minister, can now be the subject, justiciable subject of the court's control. And that was a judgment that the Supreme Court was perfectly entitled to make. What the implications are for the future of our constitutional will have to be reflected upon in the coming months and years. But it is never wise to reflect upon a court case and its implications in its immediate aftermath. It will have to be done carefully and deliberately, and this House will have to decide ultimately whether these powers are for this House to regulate and control, or whether they are for the judiciary. But at the moment, the Supreme Court has spoken, and that is the law.
Yvette Cooper.
The Attorney General's acceptance at that point that the government got it wrong in this case is very welcome. So will he now advise the Prime Minister and the government to accept and agree with the content of this Supreme Court judgment, not just the obligation to abide by its conclusion, and in particular to accept that it is wrong for this government or any government to seek to prorogue Parliament 5 weeks rather than just for a few days without giving reason, let alone, in the words of the Supreme Court, a good reason, to the public, to Parliament or to the courts that was wrong.
Hear, hear.
Well, I say to the right honourable lady that the judgment is clear. The government is assessing its short and long-term implications now, but she can be quite certain that the government will abide by its ruling and by the content and implications of its judgment.
Sir John Redwood.
What limits are there on the powers of the Supreme Court to intervene in how Parliament conducts its business? And what powers are there for them to intervene over the highly political matter of how
and if so, what was the correct test to apply to that judicial control? And it chose to delineate a test which suggests that from now on a prorogation of any length must be reasonably justified. That will, the court included in its analysis the fact that there was before the House, before the country now, a particularly acute constitutional controversy, which made it even more important that the House should sit. I have to say, and I think there's nothing wrong in venturing to express respectful disagreement, but what that will mean in future is that the court will be obliged to assess whether or not a particular political controversy is sufficiently serious, excites sufficiently heated controversy, and as to warrant the House sitting for any particular length of time. But it may, that is the test the court has set, and that is the test that now must be applied.
Dr. Sarah Wollaston.
Thank you, Mr. Speaker. What message does the Attorney General have for his colleagues in government who have been hearing and undermining Supreme Court judges? Some of this is not done in the heat of the moment. We've been hearing from one journalist that he's been sent copies of articles about Iranian judges comparing Supreme Court judges with them. Is he going to give an unequivocal message to his colleagues that they should resign if they undermine the Supreme Court's independence?
The judges do not exist immune from criticism. There is nothing wrong at all in any member of the public, be a member of Parliament or otherwise, in criticising a court judgment. But what is wrong is that motives of an improper kind should be imputed to any in this country. We are defenders of our constitution, and we must be sure in everything we say, and I agree with the Honourable Lady if this is what she means, that we do not impute improper motives. With the judgments, we can be robustly critical. With the motives, we cannot.
Jeremy Wright.
Thank you, Mr. Speaker. Is it not important, even in the course of argument on matters as important as these, to remember why we have the constitutional conventions that we do, and that government is entitled, as any other organisation or individual is, to receive legal service in private? And if it does not, and if those who ask for it to be published get their way, what will happen is that legal advice will become increasingly guarded, increasingly equivocal, and progressively less useful to government in ministerial decisions. And the consequence of that will be less good legal advice and less good ministerial decision-making.
Well, my right honourable and learned friend has great experience, as does my right honourable and learned friend sitting next to him, of the role which I now have the great privilege to occupy, and he knows how important confidentiality is to the ability of the attorney to give frank, unvarnished advice, sometimes unwelcome advice, to those who are conducting the policy of the government. So he's quite right. And he just discharged his functions, as did my right honourable friend for Beaconsfield, with great distinction, and I'm proud to have been a successor of that.
Angela Eagle.
Thank you, Mr. Speaker. The right honourable and learned gentleman has made it quite clear that the judges in the Supreme Court had every right to come to the decision they came to, and in fact they came to it unanimously in an excoriating judgment which should put the government's front bench to shame. What is his view, therefore, of a leader of the House who persists in believing and makes it known that he feels the Supreme Court have instituted a constitutional coup? Surely he cannot remain in his post if he has that view.
There is nothing wrong with expressing robust, critical views about a judgment, insofar as it imputes inappropriate or improper motive, then it is wrong. So I think it's a question of wording and of being careful with one's language. But I took my remark, insofar as I saw it reported, simply to be a robust criticism of the judgment and nothing more, which is entitled.
Sir Oliver Letwin.
Thank you, Mr. Speaker. Mr. Speaker, I have absolute respect for the integrity and the competence of the Attorney General. In the light of what I told the House this morning, can he guarantee absolutely that, save potentially a few days before a Queen's speech, there can be no question of his permitting Her Majesty's government to have a prorogation between now and the time of 31st October of this year?
What I can undertake to my right honourable friend is that there will be no prorogation that doesn't comply with the terms of the judgment of the...
Mr. Speaker, the Attorney General said that he's going to review whether advice should be published, but in answer to the former Attorney General, he upheld and defended the privacy of that legal advice. So can he tell the House the scope of the review he's undertaking? Is it just when the government is in the Supreme Court, or will it be more widely?
What I'm considering is the public interest, and whether or not there are factors in this case connected closely with the public interest generally that should outweigh the Law Officers Convention and to disclosure. But that isn't only my decision. I'm in the position in a rough and approximate way between a lawyer and his client. And I must ensure that there's proper consultation, proper reflection on what the public interest requires. And that I have undertaken to the Right Honourable Lady who asked the urgent question to do. And in due course, I will make my mind up.
Sir Christopher Chope.
Mr. Speaker, did it come as a surprise to my right honourable and learned friend that the Supreme Court ruled that the act of prorogation not not a proceeding in Parliament. And if that is the new law to which my right honourable friend has referred, would it be open to this Parliament to change the law back to what we thought it was before?
Did it come as a surprise, my honourable friend asked me? Quite a lot about the judgment came but that particular part proceeded from a quite strict or narrow interpretation of the Bill of Rights and what was a proceeding, and it was interpreted to apply the protection afforded by the Bill of Rights to the essential business of Parliament. And it was held, as my honourable friend will know, by the Supreme Court that such a proceeding, namely the execution of the Queen's Commission in the Lords in the presence of Mr. Speaker and those who attended that proceeding, was not sufficiently close to its core and essential business to attract the of the bill. It would, of course, be open to this House to decide to legislate otherwise. And no doubt that's one of the implications of this judgment that will have to be reflected upon months and years. I know that, there was a widespread view that it was indeed a proceeding in Parliament. But the Supreme Court is as entitled to redefine, or at least to take a view of its definition of the protection afforded by the Bill of Rights, as it is to invent a new legal principle, as it did in this judgment.
Anna Seabury.
Mr. Speaker, I'm sure many of us would like to congratulate the Honourable Learned Member for Edinburgh South West and Gina Miller for making sure that this remains a sovereign Parliament. The Honourable Lady asked a question of the Attorney which he hasn't answered. She asked him whether he could confirm that the Cabinet or member and he's a member of that Cabinet, had asked to see his advice, but they were denied that opportunity. Can he confirm that his advice was requested by fellow members of the Cabinet, but it was denied?
Well, let me make plain that I have never denied any member of the Cabinet any sight of any advice of mine. I am not certain who and when else asked for that advice, but I certainly have never denied it.
Rory Stewart.
Mr. Speaker, the Right Honourable and Learned Friend agree that rather than being some newfangled, innovative decision, this was a profoundly conservative decision by the Supreme Court asserting the ancient sovereignty of Parliament, and that fundamentally the principle at stake here is that, of course, neither that court nor any other court should determine whether Brexit takes place. That decision has been made by the but it is for this House, the only directly elected representatives of the people, to determine the form in which that Brexit happens.
Let me say to my right honourable friend, the Supreme Court invoked the principle of parliamentary sovereignty and the the Convention of Parliamentary Accountability, Ministerial Parliament, as a justification for making justiciable the decision to prorogue, and that's what it was entitled to do, and it effectively amounts to converting the legal convention into a legal rule. That traditionally was not thought to be possible. The Supreme Court has decided that it is, and I certainly do not in any way complain with its right to do so. But what I would say to my right honourable friend is, I would agree with him that Parliament has to determine the terms on which we leave. But this Parliament has declined 3 times to pass a withdrawal act with which the opposition, in relation to the withdrawal act, had absolutely no objection. It was then we now have a wide number of this House setting its face against leaving at all. And when this government draws the only logical inference from that position, which is that it must leave, therefore, without any deal at all, it still sets face, denying the electorate the chance of having its say in how this matter should be resolved. This Parliament is a dead Parliament. It should no longer sit. It has no moral right to sit on these green benches, and whatever
order. We've got a lot of business to transact. There is a further urgent question. There are no fewer, I say, for the benefit of those observing, 5 ministerial statements. The attorney must be heard, and so I hope will the attorney.
They don't like to hear it, Mr. Speaker. They don't like the truth. They have been asked to let the electorate decide upon whether they should continue to sit in their seats while they block 17.4 million people's votes. This Parliament is a disgrace. Given the opportunity, since I am asked, let me tell them the truth. They could vote no confidence at any time, but they're too cowardly. They could agree to a motion to allow this House to dissolve, but they're too cowardly. This Parliament should have the courage to face the electorate. But it won't, because so many of them are really all about preventing us leaving the European Union at all. But the time is coming. The time is coming, Mr. Speaker, when even these turkeys won't be able to prevent Christmas.
Mr. David Hanson.
Thank you, Mr. Speaker. I think the Attorney General will find that the moral right I have to sit in this House is due to an election called by the Honourable Lady for Maidenhead, which she lost 40 seats in. I represent my constituents as sitting in this House, and I'm here elected by the people to do so. Could he tell this House how much taxpayers' money has he spent?
All I'm suggesting to the honourable gentleman is that he gives his constituents the chance of electing him again.
Order! 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 I say to the honourable gentleman, the member for Kingston upon Hull East, that as a result of my prodigious efforts last week, audiences in New York, Boston and Zurich aware of the honourable gentleman as the noisiest member of the House. I always enjoy listening to the honourable gentleman, but when he's on his feet rather than in his seat. The Attorney General.
If the honourable gentleman is so confident that the electorate will consider that his moral right to sit here is so strong, why doesn't he submit it to them now? All we need, I offer this to the front bench of the Labour Party. All we need is a one-line bill that we could put through with the Speaker's help, fixing the date of the general election by a simple majority, and we could have the election. Why doesn't he tell his front bench to put his confidence in his constituents to the test?
Mr. Ian Duncan Smith.
Mr. Speaker, I wonder if my right honourable learned friend, having read the full summary judgment made yesterday by the Supreme Court, was also struck by something that seemed missing within their methodology. That when they stood up, they said, for the right of Parliament to hold any executive to account, at no point in there did they reference one of the ways, of course, of avoiding prorogation, it
would have been to have had a vote of confidence in the government or to have voted for a general election. Be with me that that would have been the surefire way of the opposition parties to have secured an end to any prorogation and an immediate government if so wished, but they were frightened.
Yes, I entirely agree with my right honourable friend. In our constitution, when a government can no longer govern because the Parliament has withdrawn its assent, the moral and constitutional thing to do is have the courage of your convictions, which this spineless on the front bench here do not, to place a motion of no confidence before the House. But they haven't got the guts to put that motion of no confidence because most of them don't want their own leader in power.
Carol Monaghan.
Can I maybe say first of all to the Attorney General that none of us on these benches are worried about a general election. The right honourable member for Surrey Heath has suggested that the unanimous verdict of the Supreme Court was the equivalent of the view of just a few academics, and the Leader of the House has described the verdict as a constitutional coup. Unfortunately, these views do gain traction amongst members of the Parliament. So will the Attorney General take this opportunity to give a strong statement of support both for the judgment of the Supreme Court, the importance of the independence of the judiciary?
I think, in answer to the last point, if I may, of the lady, I completely, firmly support the independence of our judiciary. In Scotland, in England, in Wales and in Northern Ireland, we have one of the finest judiciaries in the world. And the fact of the matter is the Supreme Court gave its judgment and its judgment must be respected. But that does not prevent robust criticism of the terms of that judgment, which will, I have no doubt, be subjected to that criticism. That is onside. What is not onside is the imputation of proper or inappropriate motives.
Sir Desmond Swain.
My right honourable friend, the member for Chingford, is right, Mr. Speaker. We had notice of the intention to prorogue. With your assistance, we could have entertained motions against it or even a motion of no confidence. So it was a coup, wasn't it?
Well, I know that my right honourable friend will know that I want to be, if I can, comes to the judges, though not to this shower, but when it comes to the judges, I want to be careful and careful. And it's important that we should understand that these judges are protectors of all our freedoms and all our rights.
Order! I don't know stylistic advice to the Attorney General, but his tendency to perambulate while orating is disagreeable to the House. Face the House with confidence and assurance and an acknowledgement that the House wishes to hear his every utterance. The Attorney General.
I wonder if you, Mr. Speaker, in a well-earned retirement, would like to give lessons to frontbenchers. It could be our beginnings of a new and very glorious, or even more glorious, career. I've now lost my thread entirely. They say they want me to sit down, so I'm going to. We'll defy the opposition.
Mr. Barry Shearman.
Mr. Speaker, I came into the chamber today thinking I felt sorry for the Attorney General. But as he started, I did. Fair enough. But every word he has uttered, no shame today, no shame at all. The fact that this government cynically manipulated the prorogation to shut down this House so that it couldn't work as a democratic assembly. He knows that that's the truth. And to come here with these barristers' bluster to obfuscate the truth, and for a man like him, a party like this, and a leader like this Prime Minister, to talk about morals and morality is a disgrace!
I'm not sure I could discern in that marshmallow of the rhetoric any question. But insofar there was a question, there's an answer. If the honourable gentleman thinks that the government should no longer be governing, tell his leader to bring a motion of no confidence this afternoon. Tell his leader to agree to a simple one-line statute that fixes the election by a simple majority, and we would be delighted to meet him wherever he chooses in front of the electorate. Who will judge whether the machinations which he supports and the devices he resorts to in order to make sure this dead Parliament continues are right or wrong?
Antoinette Sandbach.
Thank you, Mr. Speaker. The Attorney-General speaks of moral and constitutional courage. Can he explain to this House why the government didn't have the moral and constitutional courage to file a witness statement in the Supreme Court attesting to the truth of the position that was being outlined to the Supreme Court judges?
I can't, I'm afraid, make comments on matters that are plainly covered not only by but by legal professional privilege. But what I would say to my honourable friend is that the government's position was set out very clearly in argument, and if she follows it all, it went on for a very long time, and the Supreme Court decided it. We accept that position.
Mr. Nicholas Edward Bowles.
Thank you, Mr. Speaker. Having lost in court, the Attorney-General is keen to try his hand at another test of an election. Maybe I can help him. In paragraph 41 of their unanimous judgment, the Supreme Court referred to two fundamental principles of our constitutional law, and I quote, "The first is the principle of parliamentary sovereignty, that laws enacted by the Crown in Parliament are the supreme form of law in our legal system, with which everyone, including the government, must comply." And that is the end of the quote. Can the Attorney-General confirm that he, our government, will comply with the law known as the Benn Act, recently passed by this Parliament, that has received royal assent?
Yes.
Steve Baker.
Isn't it the case that, contrary to the shouted opinions of the front bench opposite, what the Supreme Court has done is to invent a new constitutional... Just as Lord Sumption told us on the Today programme this morning, and Lord Sumption also said that this was a revolution. He described the decision as revolutionary. So isn't it the case that prior... She shouts shocking. Lord Sumption who said it. Yes. Isn't it the case that prior to this revolutionary decision by the Supreme Court, it's quite likely, indeed probable, that his advice was entirely correct until the Supreme Court changed the law?
I'm very grateful to my honourable friend for the question. I can't disclose what advice I gave. The honourable lady who first asked this question had that answer, and I'm afraid I'm going to have to keep giving it today. But what I would say is that the Supreme Court did indeed, as it overtly and explicitly said, develop the law. It took what was a political convention, hitherto in all of the constitutional textbooks described as unenforceable by a court, and decided that it would set a test and convert it into a legal principle and a legal test. And that it was perfectly entitled to do, just as this House will in the coming months and years have to reflect on the implications of it and whether it is content to leave that position untouched. But for the moment, it is the law, and the law must be obeyed.
Stephen Doughty.
Thank you, Mr. Speaker. Can the Attorney-General be very clear
were the Director of Affairs, Nicky Da Costa, and the Cabinet Secretary, and indeed any other advisor, including the Leader of the House's office, asked to make sworn statements in these cases, and did they refuse to do so, and if so, why?
I simply cannot comment on matters that pertain to the internal preparations of cases which are covered by legal professional privilege. It's simply not reasonable to ask them to do so, particularly when it relates to individuals. So the honourable gentleman should make no assumptions one way or the other. The fact is they're covered by privilege and they must be respected.
Vicky Ford.
There are many extremely distinguished, experienced lawyers in this House, but some of us are not lawyers, and many constituents are not lawyers. So could my right honourable friend, the Attorney General, explain this very clearly? Is this a new law? Does it set a new precedent? And if it is a new law and a new precedent, will the government comply with the new law and comply with the new precedent?
What it is a new principle of law which has been found to exist by the Supreme Court, and where hitherto it has not thought that a court could go. But that is, the court is entitled to develop the common law, and that it has done. It does set a precedent. It is, unless this House, in due course, should consider, it should take action to alter that position.
Caroline Lucas.
Thank you, Mr. Speaker. While yesterday's Supreme Court decision was extremely welcome, upholding parliamentary, it should never have come to this. Our centuries-old unwritten constitution, based on gentlemen's agreements, is not purpose when dangerous populists are in office. Will he therefore consider urgent proposals for a written constitution developed with real citizens' engagement, since our democracy belongs to all of us, not just those who think they're above the law?
Well, I have to say I have a degree of sympathy with what the Honourable Lady says. I do think that as we depart the European Union, there is ground for thinking again about our constitutional arrangements, how they should be ordered, and I think a widespread public consultation of the kind she's describing would be essential, because any new constitutional arrangements would have to be sanctioned by the widest possible public support and assent. So I do have some sympathy. Over the coming months and years, this will be a subject of important concern to this House.
Dr. Julian Lewis.
Given that three of the most distinguished lawyers in the country, including the Master of the Rolls and the Chief Justice, found in the lower court that the government's case was entirely correct, can the Attorney General, enlightened, puzzled non-lawyers like me as to why not even one out of 11 Supreme Court judges could be found to agree with them?
I think my honourable friend is asking me to look there into a crystal ball. Far be it from me to fathom the inscrutable minds of their lordships in the Supreme Court as to why they chose not to dissent if they were minded to dissent, or to agree if they were minded not to agree.
Chris Bryant.
Thank you, Mr. Speaker. I, for one, am delighted that we are sitting. But the Attorney General is absolutely right about one thing. The result of yesterday's ruling is that all future prorogations will be justiciable by the courts. The only answer to that, frankly, is legislation by this House. My gentle suggestion is that it might be a good idea if prorogations in the future were only allowed to proceed if there had been a vote in this House in favour of it.
Well, that is, if I may say to the honourable gentleman, that is as I would expect from him, particularly in his new guise as an aspirant to even higher office, constructive, helpful, impartial, and a model.
That's cool.
I think but I'm not sure that the Attorney-General is seeking to help the honourable gentleman. Charlie Elphick.
Mr. Speaker, can I ask the Attorney-General that in applying this new legal principle that has been created or invented by the Supreme Court, how many prorogations in the last century would have passed muster to the test that has been created? Can this longest session that this House has had since the Civil War now be lawfully brought to an end and a Queen's speech lawfully brought forward? And finally, is royal assent a proceeding in Parliament?
As to my